Hello everybody. Hello, welcome. I do have comments off today so I can just get reading, which is my goal at this point. We have a lot of things going on today. Everybody, I will be on multiple times today, but for this first one, let me make sure I'm in frame here. We do have the order that just came out of New York regarding the New York criminal case. So we've got so much going on, everyone. I will be back later tonight on a live at 7 o'clock at my usual time to go through what's been going on. But because there's so much going on, I felt I needed to kind of hop on here in between and read a few things. So I do have comments off so that I can kind of just make it through this order so we can kind of talk about it. So just so everybody knows here, this is the Supreme Court of the State of New York for the County of New York. This is the people of the State of New York versus Donald Trump, and this is the criminal case. They had a hearing just today, an omnibus hearing, to decide whether or not there was going to be a dismissal. The judge decided, no, we're not going to dismiss the case. We are going to go forward. So this case is set for March 25th when we will start doing voir dire at that point. So after today, everybody, we will need to start getting ready for trial. So I wanted to come in and read the order to you that was just issued. It was just set out so that everybody knows where we're at. So with that, everyone, I will kind of jump on here quick and just start reading. We're going to kind of just get into it today as quick as we can because we have so much going on. But again, I will be on later tonight. We do have a couple of filings for the Supreme Court regarding Mr. Trump, so I will be back on regarding those later. And we will also be talking about the Georgia RICO case. But at this time, everybody, this is the New York case. Let me make sure I've got my little tag here. The New York criminal case trial is set for, February 15th. Oh, I'm sorry, the order is for today. Sorry about that. Oh my gosh, everybody. I'm a bit wacky today. So February 15th is today when this order came down. So we'll just go through this order at this point. We have the judge here, Judge Merchan. So defendants' motions are decided as follows. On September 29th of 2023, defendant Donald J. Trump, hereafter defendant, filed omnibus motions seeking various forms of relief, including dismissal of the indictment on the grounds that the charges are legally defective and because of pre-indictment delay. Defendant also demands a more robust bill of particulars. We talked a little bit about what a bill of particulars is. It is something that can be used by defendants to clarify exactly what the charges are. The people responded on November 9th of 2023. Defendant's reply was filed on November 21st of 2023, and the people's reply on November 27th of 2023. We have our first footnote here. The following allegations are taken from a review of the grand jury minutes and accompanying exhibits. Defendant's memorandum of law in support of Donald J. Trump's omnibus motion, defendant's affidavit in support of his omnibus motion, and accompanying exhibits. Defendant's reply and people's memorandum of law in opposition to defendant's omnibus motion and accompanying exhibits. The Christopher Conroy affirmation in support of the people's opposition to the defendant's omnibus motion and the people's reply, and the statements of fact accompanying the indictment. So if you are interested in looking these up, everybody, right here we have memorandum of law in support of President Donald J. Trump's omnibus motion here. Again, this is the index number if you are interested in that. And then we do have the response by the government here. So People's Memorandum of Law. These were filed back in November. And then after that, the court set the hearing for today. So let's go ahead and dive right back in then. The people presented evidence to the grand jury that between August of 2015 and December of 2017, Michael Cohen, a lawyer who worked for the Trump Organization and also held the role of defendant's special counsel, paid $130,000 to Stormy Daniels, also known as Stephanie Clifford, hereinafter Daniels, Prior to the 2016 presidential election, the payment was part of an agreement between the defendant and Daniels, whereby Daniels agreed not to publicize information about a particular kind of encounter she had with the defendant. Defendant was concerned about the negative impact an information could have on his campaign for president of the United States. By way of background, on or about August of 2015, defendant met with Cohen and David Pecker, the chairman and chief executive officer of America Media Incorporated. And I'm just reading through the order that was given today regarding the, what we're calling the hush money case, everybody. Defendant Cohen and Pecker came to an agreement that AMI would assist defendant with his campaign for president by alerting Cohen if any potential negative story about the defendant was discovered, so that a plan could be implemented to prevent its publication. The agreement was communicated to Dylan Howard, then AMI's chief content officer and editor-in-chief of the National Enquirer. As agreed, on or about June 2016, Howard alerted Cohen about a woman named Karen McDougal, who alleged that she had an extramarital relationship with defendant. Defendant directed Cohen to purchase the information from McDougal to prevent the story's publication. Subsequently, AMI paid McDougal $150,000 with the understanding that the defendant or the Trump organization would reimburse. So, again, we have this question of money here. AMI. So the payment to McDougal was recorded in AMI's books and recorded as a promotional expense and paid out of Pecker's AMI budget. This was vital in executing the plan to keep McDougal's information as well as payment for said information out of the public eye. By keeping the payment in the president's budget, Pecker was able to avoid approval requirements that would have applied had the payment been accurately recorded. And then we've got a citation here. So let's just make a note right here, everybody. We have woman number 1, all right? So I think a lot of people forget that there are actually a couple of women involved in this case. So let us not forget, we have woman number 1 here. Thereafter, defendant and Cohen discussed how the rights to the McDougal story could be purchased from AMI and how AMI would be paid. After the conversation and further discussion with then Trump Organization Chief Financial Officer Alan Weisselberg, Cohen created a shell company called Resolution Consultants, LLC, on or about September 30th of 2016. Cohen and Pecker came to an agreement that AMI would be paid $120,000 from Resolution Consultants, LLC, in exchange for the rights to McDougal's story. An invoice was created which described this payment as advisory services. So let's just make a note that we have an invoice, and we also would call that evidence here. On or about October 10th of 2016, Cohen spoke with Keith Davidson, and then attorney for Daniels, about Daniels' encounter with defendant. At defendant's direction, Cohen and Davidson agreed that Daniels would keep the information about the encounter with the defendant concealed out of the public's eye in exchange for $130,000. So let's just note, woman number 1 was $150,000. And woman number 2 is $130,000. All right, so we'll just keep those in our minds here. As with the McDougal agreement, Cohen discussed payment for the Daniels agreement with Weisselberg. After this discussion, Cohen agreed to pay Ms. Daniels after confirming that defendant would reimburse him. To execute the transaction, Cohen opened a bank account in the name of Essential Consultants, LLC. He transferred $131,000 into the account from his personal funds and then wired Davidson $130,000 from the Essential Consultants account. On or about January 2017, defendant Weisselberg and Cohen agreed that Cohen would be paid a total of $420,000 to reimburse him for the payment to Daniels. The total represented a $60,000 year-end bonus to Cohen for his work with the Trump Organization in 2016. The $130,000 payment he made to Daniels, a $50,000 payment to Cohen for expenses he claimed he incurred working on defendant's campaign, and an additional $180,000 to ensure Cohen was fully reimbursed after taxes. It was agreed that the $420,000 would be paid in installments on invoices Cohen would periodically send to defendant through the Trump Organization for alleged legal services rendered. On or about February of 2017, the defendant and Cohen met to formalize this arrangement. From February 2017 through December of 2017, Cohen submitted invoices to the Trump Organization as per the agreement with defendant. This included 11 invoices that were addressed to Weisselberg. So if you want to know how many counts we have 11 because we have 11 invoices. All right, so the Trump Organization detailed general ledger here. Checks were then generated and sent to Cohen. The first check, which was signed by Weisselberg and Eric Trump, and the second check, which was signed by Weisselberg and Donald Trump Jr., were paid from Trump Revocable Trust. The remaining 9 checks were signed by the defendant and paid from his personal bank account. On March 30th of 2023, the defendant was indicted by a grand jury on 34 counts of falsifying business records in the first degree in violation of Penal Law Section 175.10, hereafter PL. The invoices detail general ledger entries and checks from the basis of the 34. The checks form the basis of the 34 counts in the indictment. Number 1, pre-indictment delay. Defendant moves to dismiss the indictment on the grounds that he was prejudiced as a result of the alleged pre-indictment delay. In the alternative, defendant seeks a Singer hearing to determine whether the delay between the commission and the alleged crime and his arrest violated his due process rights, citing the Singer case here. For the reasons set forth below, this branch of the defendant's motion is denied. So we have our first denial, all right. And then I will skip ahead just a little bit, everybody. We have, when considering pre-indictment delay, the court must analyze 5 factors. So they set up the 5 factors and then analyze those 5 factors, and then they say, no, we don't have a violation of those 5 factors. So I am skipping through this just a bit, but again, this is available online here. So we've got a lot going on in this order, so I will skip ahead just a little bit. All right, next, sufficiency of the charges. So this is really getting into kind of the meat of the order here. So they go through with the 5 factors. No, we don't have an issue. So here's number 2, sufficiency of the charges. Defendant's motion to inspect the grand jury minutes for legal sufficiency pursuant to criminal procedure law hereinafter CPL section 210.30 sub 2 is granted. So we have a piece of his motion to inspect those grand jury minutes that has been granted today. All right. The standard that is to be applied on a motion to dismiss an indictment due to legal insufficiency is whether there was competent evidence which, if accepted as true, would establish every element as an offense charged and the defendant's commission thereof. And we're citing case law here. A grand jury may indict a person for an offense when A, the evidence before it is legally sufficient to establish that such person committed such offense, and B, competent and admissible evidence before it provides a reasonable cause to believe that such person committed the offense. Criminal Code section set out here. When conducting such a review, the court must view all the evidence in the light most favorable to the people, so that's the government. And then we're citing case law here. For the reasons set forth below, defendant's motion to dismiss the indictment on the grounds that the charges as presented to the grand jury are legally insufficient is denied. All right, so there's our next ruling. So he is asking for transcripts. That's okay. He can have that. But his motion to dismiss based off of insufficient charges, that has been denied. Likewise, defendant's request to review the grand jury minutes in their entirety is denied. So we've got a partial allowance then. So there's a big difference between looking specifically at particular pieces of grand jury minutes versus the entirety of the grand jury minutes. A person is guilty of falsifying business records in the first degree when he commits the crime of falsifying business records in the second degree. and when his intent to defraud includes an intent to commit another crime or to aid and conceal the commission thereof. Under the culpability definition of terms, and under this section of the law, act, voluntary act, omission, conduct to act, and culpable mental state are defined. Intent to defraud is not defined within that section. However, courts in the First Department have interpreted the culpable mental state broadly. First Department being the jurisdiction here in New York. And we're citing case law here. Intent to defraud is not constricted to an intent to deprive another of property or money. In fact, intent to defraud can extend beyond economic concerns, citing case law here. And then, for example, the defendant in a prior case was acquitted of a grand jury. No, we're going to flip. Just 1 second. A grand jury larceny, but found guilty of falsifying business records in the first degree. The court held that the verdict was not repugnant, as the charge to the jury did not require a finding that the defendant was the same person who committed the underlying grand larceny. The term business records, as defined by law, is as any writing or article, including computer data or computer program, kept or maintained by an enterprise for the purpose of evidencing or reflecting its condition or activity. The definition of business records is not a narrow one, as there are a wide array of factors that the court considers according to case law here. So they're going into what business records are. Enterprise is defined in Article 175 as any entry of one or more persons, corporate or otherwise, public or private, engaged in business, commercial, professional, industrial, and so on. This definition encompasses any person or group of persons engaged in any organized activity for which records are kept. So the judge is just clarifying the different sections of New York law, setting up what an enterprise is, what business records are, and what falsifying means. So going into falsifying business records in the first degree requires that a defendant have the intent to commit another crime or to aid and conceal the commission thereof. Thus, the statute does not require a defendant to actually be convicted of other crimes, but merely that he has to intend to commit another crime. This element of the law is satisfied so long as the defendant intended to commit or conceal the other crime. The focus here is on that element of intent. Defendant moves to dismiss all counts in the indictment on the grounds that 1, he did not cause false entries in the business records of an enterprise. 2, the people have not identified a viable object offense. And 3, the grand jury was not presented with evidence of intent to defraud. Finally, defendant asked this court to compel the people to produce the complete set of grand jury minutes. Number 1, business records. Now, I will be skipping through a little bit here. Again, this is a huge order, so I will just kind of hit the highlights, everybody. Defendant first argues that records at the heart of this matter, i.e. the invoices, checks, and general ledgers that were generated to reimburse Cohen, came from defendant's personal accounts and are not the records of the Trump Organization. Defendant further argues that the mere fact that the records were held at the Trump Organization is of no import. Therefore, the argument follows that they are no business records that reflect the condition or activity of an enterprise as required by the law. And 2, to support this position, defendant cites multiple cases. Defendant further argues that the instant matter is distinguishable from the prior case, indictment here, where the ledger entry in question related to benefits that were purportedly received as income by Weisselberg as the chief financial officer of the Trump Organization. This court reasoned that the entry deleted from President Trump's personal ledger was a business record of the Trump Organization for purposes of this section of the law, because it was both 1, kept and maintained by the Trump Organization, and 2, evidenced the Trump Organization's obligation vis-a-vis Weisselberg's salary for the Trump Organization. Defendant's memo is being cited here. Whereas here, defendant argues Cohen was paid out of defendant's own funds for Cohen's work as defendant's personal employee, not a Trump Organization employee. And then they go into what the government's position is on that here. So let's look into how the judge is ruling on that. Again, everyone, I'm kind of trying to hit the highlights here. Let's go through this very lengthy order. All right, so here's how the judge is holding for this issue on whether or not these were personal records or business records. This court agrees with the government's contention that the invoices, checks, and general ledger entries are in fact business records for purposes of the charge of falsifying business records in the first degree. In prior case law, the court held that the detailed general ledger became the business record of the Trump Organization once Mr. Weselberg was paid the salary out of DJT's personal funds. Put another way, Trump's detailed general ledger is the business record of the Trump Organization because the entries evidence the Trump Organization's obligation vis-a-vis Weselberg's salary. This court further held that Trump's detailed general ledger was a personal record of Trump and not the books and records of a business entity is of no legal consequence. The same rationale applies here. The evidence presented to the grand jury demonstrated that while Cohen was an employee of the Trump Organization, he also handled personal matters for a defendant. That defendant owned the Trump Organization entities as the sole beneficiary of the Trump Revocable Trust, and the $60,000 of the $420,000 repayment to Cohen was for work at a Trump Organization as a Trump Organization employee in 2016. Indeed, the payments here exemplify the intermingling of the Trump Organization's business records and defendants' purportedly personal expenses. Yikes. Defendant and the Trump Organization are intertwined to such a degree that it is of no legal relevance that some of the monies paid to Cohen came from the defendant's personal funds. So there you have it. So the judge is saying, nope. Now, the other argument that the defendant had on this other crime issue, the defendant next argues that the indictment fails to make out the element of an intent to commit another crime or to aid or conceal the commission thereof. Defendant further argues that the four theories set forth by the people to satisfy the other crime element are not viable and are therefore cannot serve as object offenses under the statutes. The four theories being violations of 1, the Federal Election Campaign Act, 2, the New York election law, 3, tax law, and 4, defendant's intent to violate the New York law or intending to commit or conceal the falsification of other business records. Defendant's memos being cited here. So the government's primary contention with defendant's argument is that the statute does not require that the other crimes actually be committed. So this is a huge issue with inchoate offenses, everybody, or any kind of offense where you have dishonesty when they're looking for the actual crime to be committed. Rather, all that's required is that the defendant have the intent. That is, he acted with conscious aim and objective to commit another crime, citing multiple pieces of case law. So let's fast forward a little bit here and see what the judge says about that. So it looks like, we'll start up here. The court has considered the respective arguments of the parties and finds that the evidence presented to the grand jury for the first three theories was legally sufficient to support the intent to commit the other crimes element of falsifying business records in the first degree. However, the court cannot make the same finding as to the fourth theory. The people are therefore precluded from arguing this fourth theory to the jury. So the people set out 4 theories of this other crime intent, and they said 3 will work, but 1 will not. Nonetheless, the people are permitted to present evidence at trial that stems from the 4th theory to the extent that the evidence advances any or more of the first 3 theories. So this is pretty traditional, everybody. When this can happen, the government's saying, look, we've got 4 points of law that we're going to argue regarding the elements that we need to prove. And the judge is saying, well, 3 of those are good, but you can't use the 4th one, but you can use the 4th one to prove the other 3. So that's pretty typical. So we've got the Federal Election Campaign Act here. So defendant argues that the crime elements in this law must have occurred in New York. Therefore, an out-of-state crime or federal crime, such as a violation of the FECA, cannot satisfy this element of the charge. Defendant largely relies on the Witherspoon case to support his argument that a restrictive reading of another crime is required. And then he goes through this analysis of Witherspoon. Now, everybody, I am going to fast forward again a little bit because we already know what's going to happen here. I've already kind of told you the judge's ruling, and so now we have the legal analysis in case Mr. Trump wants to appeal it. All right, so we go through. That piece is already allowed. The next piece is the New York election law here. Defendant next argues that New York election law is limited to elections for state and local offices and cannot be used to address allegedly wrongdoing related to federal elections. And then we're citing case law here. Defendant's argument is not an object offense under here, and his argument is failing. Specifically, the defendant claims that because the allegations is that he tampered with the 2016 presidential election, then New York election law is not applicable because its applications limited to elections for public office, a term which the defendant claims does not include federal elections. All right. Then we're citing a New York election law here titled Applicability of the chapter explicitly states, this chapter shall govern the conduct of all elections at which voters of the state of New York may cast a ballot for the purpose of electing an individual in a party position or nominating or electing an individual to a federal, state, county, city, town, or village here. So the New York law applies to ballots cast for any election, including federal. So his argument that it does not apply because it was a federal election will fail, and that is what the court has held here. Nope. So next, the third piece is his tax law argument. Let's take a look at that quick. Defendant next argues that there's no evidence that he intended to violate any tax laws because 1, Cohen's tax returns were not presented to the grand jury, and 2, defendant was not aware of the purported grossing up scheme that Cohen and Weselberg concocted. Oh dear. Defendant also claims that the alleged violation is of no consequence because the state was not financially harmed. Oh, not harmed. We've heard that argument before. So not harmed by his tax issues. So what's the problem, right? And instead would wind up collecting more tax revenue. Oh my gosh. The people submit that there is sufficient evidence before the grand jury that the defendant knew he was paying Cohen not for legal services, but as reimbursement for the payoff to Daniels. This evidence was presented in the form of Cohen's testimony, Weselberg's handwritten note, and the payment to Cohen would be grossed up to twice its amount to account for tax purposes. Testimony from McConney that the reimbursement was doubled to account for the taxes, that McConney was not aware of any other incident where Trump Organization had doubled up on an expense reimbursement for tax purposes. The people further argue that it's irrelevant that Cohen's tax returns were not presented to the grand jury because, again, the people need only demonstrate an intent to commit a crime. Not that the intended crime was actually completed. In this instance, the intended crime was a violation of New York's tax laws. So, defendant's argument is not persuasive, all right? So the court is saying, nope, nope, we're not going to allow for that. The grand jury minutes demonstrate that Cohen was paid $420,000 as reimbursement for money he paid Daniels pursuant to the terms of the agreement with the defendants. The $420,000 represented the original $130,000 payment to Daniels, a $60,000 bonus for Cohen's work at the Trump Organization, a $50,000 payment for tech services. Tech services, that's funny. Yeah. And the remaining $180,000 to ensure that Cohen would be made whole after adjusting for income taxes payable. The evidence before the grand jury was legally sufficient to establish the defendant knew the amount being paid to Cohen was not for legal services, but was rather for a reimbursement to Daniels. So that's the next holding, everybody. So the court's saying, you knew there's sufficient evidence, so I can't dismiss the indictment because there's sufficient evidence here. The court's not persuaded by defendant's argument that the people did not meet their burden because Cohen's tax returns were not introduced to the grand jury. Similarly, this court disagrees that the alleged New York state tax violation is of no consequence because the state of New York did not suffer any financial harm. This argument does not require further analysis. Ooh. So now the court is saying that argument is ridiculous, so we're not going to talk about it. All right, and D, intent to violate this section of the law. As to the people's fourth theory, so keep in mind the fourth theory, the government's not going to be allowed to use in trial, everybody. They can use it to support the other three, but they cannot argue it on its own. So let's take a look at this one. As to the people's fourth theory of other crime, defendant argues that there is no evidence that he knew that AMI invoices were being falsified and that the alleged falsification occurred on August of 2016, long before the time frame charged in the indictment. Defendants claim that there is no evidence presented to the grand jury that the defendant acted to conceal these records, nor was there evidence that Pecker held an intent to defraud. Lastly, defendant argues that the McDougal invoice should not have been introduced into evidence before the grand jury because the people failed to lay the proper business record foundation. Now remember, everybody, we have two women. We have woman number one here, and we have woman number two. And so he's saying woman number one's invoice shouldn't have been presented because the foundation wasn't properly laid. It's the people's position the defendant knew about AMI's falsification of its records, specifically that AMI mischaracterized the purchase of the McDougal and Daniels stories as promotional expense rather than editorial expenses, so that Pecker could circumvent spending caps. They also claimed defendant knew Cohen had created a shell corporation to facilitate and conceal the transaction, and therefore that this too could serve as an other crime. Without the court deciding whether the defendant knew about the falsification, so the court's saying, I'm not going to decide on intent, everybody, or knowledge. So the court's being pretty clear about that. The court is not convinced that this particular theory fits into the other crime element. So that's where the government is losing their fourth argument, all right? Because the court's saying, I'm not sure that this is actually working. But it does not seem that it's intertwined and advances the other three theories discussed. For example, in support of the fourth theory, the people argued that the participants in the defendant's election fraud scheme also caused the falsification of the New York business records to help defendant execute and conceal the scheme. Sorry, everyone. It appears that such an argument goes to the people's theories, which both directly involve the defendant's intent to violate those particular statutes. In deciding this branch of defendant's motion, the legal standard the court must apply is whether the evidence presented to the grand jury was legally sufficient to make out the charges, not whether the people have proven the charges beyond a reasonable doubt. Through that lens, the people's first three theories clearly satisfy their burden as to the other crime element of the charges. However, the court cannot make the same finding as to the fourth theory, and the people are therefore precluded from arguing this fourth theory to the jury. So they may not use that fourth theory, which is, they still have three others. So they still full trial on everybody. Finally, defendant argues that he did not intend to cheat anyone out of money or property through the alleged false entries, and that because the alleged falsification of business records occurred in 2017, any evidence pointing towards an alleged intent to defraud 2016 is not relevant. The people responded that the intent to defraud does not require that a particular person or entity lose money, property, or something of value. For purposes of the charges, it's sufficient to harbor the general intent, general as opposed to specific intent, everybody, to defraud any person, which is the difference between defamation intent. That's a specific intent crime. In support, the people cite case law here, and they're quoting their case law here. The people also contend that the defendant's actions in 2017, namely creation of the invoices, daily, general ledger, and the checks cannot be analyzed in a vacuum and must instead be viewed for what it is, the culmination of a scheme defendant concocted in 2015 and 2016. Oh, there's an orange, that's funny. As a result, the defendant's intent to defraud prior to 2017 is relevant. The people submit the defendant's intent to defraud was established by the grand jury by evidence that the defendant sought to suppress disclosure of information that could have negatively impacted the campaign for president of the United States, and that he made false entries into relevant business records in order to prevent public disclosure of both the scheme and the underlying information. In substance, the people argue that the defendant's intent to influence the 2016 presidential election by violating election laws satisfies the intent to defraud. So, what does the court say? This court finds that legally sufficient evidence was presented to the grand jury to satisfy this element of the crimes charged. So again, this is all because of a motion to dismiss. Mr. Trump saying you did not have sufficient evidence to take this indictment forward. This judge said, well, on this one you do. The term intent to defraud carries a broad meaning and is not limited to the causing of financial harm or the deprivation of money or property. To reiterate, controlling authority holds that the people need not demonstrate intent to cause financial harm to prove that defendant had the requisite intent to defraud under the falsifying business records statute. The defendant's argument to the contrary is unavailing and contrary to settled law. We're just going to highlight that because that tends to be an overall theme here. Settled law. All right, so let's keep moving along here. They're saying, by the way, the First Department or our appellate courts say the same thing. So the payments were made through Cohen, who was reimbursed by the defendant in the form of payments through the Trump Organization. The grand jury, when viewing the evidence, could find reasonable cause that an offense was committed and that the defendant committed it, namely the defendant possessed the requisite intent to defraud either the voting public, the government, or both. So the intent was there. Next, production of legal instructions to grand jury. So let's take a look at that. Defendant moves this court to compel the people to produce the full set of grand jury minutes, including but not limited to the instructions given to the jurors and responses to juror questions. This motion is denied. So that's a very broad request, usually involving a fishing expedition and not one that the defendant is entitled to. Remember, at the time we have a grand jury, we technically don't have a defendant because no one's been indicted yet. A party seeking a disclosure of grand jury minutes must establish a compelling and particularized need for them. So you have to be specific. If that burden is not met, the reviewing court must then balance various factors to determine whether disclosure is appropriate. The decision is in the reviewing court's discretion. Defendant argues that production is warranted as the indictment does not provide sufficient notice of the object offense theories that the people relied on and is seeking the indictment against the defendant. Again, the judge has already held that there are plenty of object offense theories. Defendant's memos being cited here. Defendant also argues that the people improperly introduced evidence related to the AMI's non-prosecution agreement with the United States Attorney's Office regarding the payment to McDougal, and then we're citing the defendant's memo again. So let's take a look here. Oh, thank you so much, Susanna. I appreciate that. Defendant's argument and case law in support are not persuasive. So no, you're not going to win on that one. Sorry. Defendant relies on this case here, but the underlying facts of that matter are inapplicable to those before the court. Let's just highlight that again because that's a fun statement. So yet again, the case law being cited is incorrect. Yikes. Oh my goodness. All right. As a defendant has failed to establish a compelling and particularized need for disclosure, the court does not need to address the second prong of the analysis. Defendant's motion is denied. So if he wants to have the full minutes of the grand jury, he's not going to be getting that. So too bad. So selective prosecution. Oh, all right. Defendant moves to dismiss the indictment on the grounds that The DA out of New York allegedly targeted him for prosecution in violation of the Equal Protection Clause of both the United States and the New York state constitutions. In the alternative, defendant argues that he has made a sufficient showing of animus and desperate treatment to require this court to order the people to provide discovery and grant a hearing on their claims of selective prosecution. So we've got another selective prosecution claim, everybody. Although defendant argues that he has been impermissibly targeted, he is not clear as to the underlying theory why he is purportedly being targeted. All right, now we've got footnote number 5 here. For example, in People v. Trump, here, defendant explicitly states that they were being selectively prosecuted on the basis of Donald Trump's political views and in an effort to stop him from exercising his free speech rights. Defendant in the instant matter has not clearly made any such argument or representation. Whoops, I probably should include that. For the reasons stated below, this portion of the defendant's motion is denied, including his request for a hearing. So nope, there's no selective prosecution. You have no support for your argument. The burden is on a defendant who makes a claim of selective prosecution, and that burden is significant. A presumption exists that enforcement of the laws is undertaken in good faith without discrimination. It's well settled the public authorities are forbidden from enforcing valid law with an evil eye and an unequal hand, so as to practically make unjust and illegal discriminations between persons in similar circumstances. However, a defendant raising a claim of selective prosecution must show that he was selectively treated compared to others similarly situated. To succeed on a motion to dismiss for selective prosecution, there must be a showing that selective application of the law was deliberately exercised upon the impermissible standards such as race, religion, or some other arbitrary classification. In essence, there are 2 prongs the defendant must fulfill to succeed in his claim. He must demonstrate 1, he was selectively treated when compared to others similarly situated, and 2, that such treatment was based on impermissible considerations. And then we go through the different prongs analysis here. The defendant has failed to carry the burden of demonstrating desperate treatment, as his claims are devoid of evidence that the law has not been applied to others similarly situated, individuals that have been prosecuted by the New York DA. Further, the court finds that the people have demonstrated that they have previously commenced actions where the accused was charged with this section of the law for falsifying business records with the intent to commit or conceal the commission of another crime. In fact, the people note that their office has brought approximately 437 cases charging violations. So, and then the court is saying, well, they have charged you pretty similarly. Again, we'll go through, I'm just kind of fast forwarding because this is a long opinion here, everyone. Defendant has failed to demonstrate a reasonable probability of success on the merit that these claims, and therefore his application for a hearing and additional discovery on the issue of selective prosecution, is denied. So he has not shown any evidence that he's being treated any differently than anyone else who has been charged in similar ways. The defendant has not overcome the presumption that the people's prosecution of this matter has undertaken in good faith and without discrimination. Keep in mind, this case has been going on for quite a bit, and there have been multiple motions regarding the DA being removed and so on. All right, number 4, dismissing the indictment as time barred under the statute of limitations. Oh, we've got a statute of limitations argument, everybody. Statute of limitations. All right. Defendant moves to dismiss the indictment on the ground that the charges are time barred. The people commend that an executive order issued by Governor Andrew Cuomo during the height of the COVID pandemic extended the deadline for the filing of these and all criminal charges, and a lot of states have that. Specifically, the people refer to Executive Order 202.8 issued by the governor on March 20th of 2020, later extended by Executive Order 202.101 on April 6th of 2021. Further, the people invoke this section of the law, which provides that any period following the commission of the offense during which 1, the defendant was continuously outside the state, or 2, the whereabouts of the defendants were continuously unknown and continuously unascertainable by the exercise of reasonable diligence, should not be included when calculating speedy trial. And that's pretty normal for a lot of places. So let's again fast forward here. So they're just going through the law that allows for that time change. Since the court finds the indictment was timely brought as a result of the tolling occasioned by the governor's executive orders, it declines to address the people's other theory pursuant to the law that the filing deadline was also extended because defendant was continuously out of New York. So the court here is saying the governor's executive order was valid, so your indictment was filed validly. Whether or not he was out of state and could not be found, that issue we're not going to address because we don't need to. All right, number 5, multiplicious counts, everybody. All right, we're coming down to the final piece. Who knew we could get through an order this long, this quickly? Here we go. Defendant moves to dismiss counts in the indictment as multiplicious on the theory that the indictment groups sets of charges based on the same alleged payments to Cohen. Oh my gosh. Wow. This is a reach. This is really a stretch. Let's take a look here at the footnote. This court notes the defendant does not explicitly state which counts in the indictment should be dismissed as multiplicious. Defendant provides an overview of each charge in the indictment and how the documents that have allegedly been falsified related to each charge. For example, counts 8 through 10 in the indictment pertain to the April 2017 payment to Cohen, and each count is related to one record: the check stub, invoice, and general ledger. So defendant argues that it's improper to attribute multiple charges related to each payment Cohen received, since each grouping, i.e. the invoices, checks, and daily general ledger entries, are the producer of the same alleged criminal act. The indictment is multiplicious when a single offense is charged in more than one count. Each count in the indictment may charge one offense only. The people put out their argument, so then let's see what the court says here. The court agrees that each document in the indictment is an alleged separate false entry. Well, I should hope so. Oh my goodness. That can support a separate count. The court's satisfied that the indictment adequately describes the charges of 34 discrete crimes. Defendant's reliance on the Quinn case is misplaced. Oh, let's highlight that again. Your law is incorrect, sir. In Quinn, then they're explaining why the law is wrong that he quoted. Defendant's motion to dismiss the counts in the indictment on the grounds that they are multiplicious is denied. All right, so his other grounds for denial, that's denied. Dismissal. Oh my goodness. All right, everybody. Motion to compel the people to provide additional particulars. All right, this kind of gets into an area where the Bill of Particulars is a tool that defendants can use, and it's set out in certain situations. It's very necessary. But as prosecutors, Bill of Particulars just means you kind of being a jerk. So there's a little insight into it. Defendants seek further particulars regarding the pending charges. Specifically, defendant seeks additional information as follows. 1. Final and conclusive notification of the object crimes relied upon as the predicates for the felony charge under this section of the law, if the people continue to rely on election law, section 17, as an object offense, the unlawful means alleged, and 3, if the people continue to rely on tax law as an object offense whose tax records were intended to be falsified. 4, if the people continue to rely on another section of the law here as an object offense, the particular enterprise and records that were allegedly falsified. And 5, the factual basis of the people's intent to defraud with respect to each count. Defendant's memo is being cited for the reasons set forth below. Defendant's motion is granted in part and denied in part. Ooh, granted in part and denied in part. Controversial. What? All right, let's see what happened. What happened? Come on, New York. Do your job. All right, let's take a peek here. So So on April 27th, defendants served the people with a request for a bill of particulars. The people responded May 12th. In response, the people represented to the defendant that he was not entitled to certain information, namely the other crimes that the people were relying upon to support the charge of falsifying business records in the first degree. Instead, they provided the 4 other crime theories referenced above. All right. The people directed defendant to the statement of facts which accompanied the indictment, as well as pending discovery for a more thorough explanation of each of the 4 theories. In response, defendant asked the people to identify the person or persons that defendant allegedly intended to defraud. The people declined to provide the information, citing a case for the proposition that they are not required to establish that a defendant acted with the intent to defraud a particular person or business entity. To date, the people have provided well over 1 million pages of discovery. Boy, we're really getting into counting each page of discovery here, everybody. To the defendant, in addition to the statement of facts, the discovery includes the grand jury testimony, the entirety of the exhibits produced to the grand jury, audio recordings, tax materials, various financial documents, and documents received in response to subpoenas issued in various entities, to various entities, including AMI. The people have also represented that the exhibits introduced to the grand jury will be introduced at trial. The purpose of a bill of particulars, all right, here we go. Now we're getting into it, is to define more specifically the crime or crimes charged in the indictment, or in other words, to provide clarification by furnishing information as to the substance of the factual allegations. And then we're citing that a defendant must be provided with fair notice of the accusation against him in order to prepare defense. A defendant is entitled to information regarding the factual circumstances underlying the accusation. This is to ensure the defendant is not surprised at trial, and so they are aware of precisely what it is they are to defend against. Again, citing another article. When the prosecutor has refused the defendant's request for a bill of particulars, the burden is on the defendant to satisfy a 2-pronged test. First, the item of factual information requested must be one that's appropriate for a bill of particulars, and 2, the information must be necessary to enable the defendant to adequately prepare or conduct a defense. All right, I'm really curious what the judge is trying to rule here. Let's see. The point of contention between the defendant and the people appears to come down to the application of this case. The defendants in that case were accused of committing a crime of burglary in the 2nd degree in violation of the law, which requires the people to prove the defendant entering into a building with the intent to commit a crime therein. The court held that the prosecution did not have to identify the crime the defendant intended to commit. Defendant correctly points out the people have not cited a case that applies a Mackey to this particular law. Defendant also directs this court's attention to the dissent in Mackey, where the judge expressed concern the majority's ruling would place the defendant at a significant disadvantage at trial, as would be exposed to unfair surprise by prosecution. The people rely upon the plain language of the code sections, which requires the intent to commit a crime, and the other code section, which requires an intent to commit another crime. Essentially, neither statute requires proof that a defendant committed or was convicted of the intended crime, nor does it require identification of the said crime. Okay. As discussed in Section 2, there is consensus that there's no requirement that the prosecution allege or establish that a particular crime was intended to be committed, citing case law. Nor is there a requirement that there be an intent to defraud any particular person. Okay. A plain reading of the statute demonstrates that it's nearly identical to the other statute in the other case, and the elements required to prove each offense are the same. Thus, in this court's view, the people are not required to specify the other crime. Okay, nonetheless, the people have identified 4 theories which they intend to present at trial, specifically that defendant intended to violate these laws and the defendant intended to commit or conceal the falsification of other business records. In fact, the people have not only informed defendant of several other crime theories, but as previously stated, they have supplemented that with a detailed statement of facts and voluminous discovery in support of those theories. This court finds the people have far exceeded the requirements. All right, so we far exceeded the requirements. So what is this? What's he saying here? Spit it out, Judge. Dang. Regarding defendant's first request seeking final and conclusive notification of object crimes, Mackey, so prior case law, provides that this court agrees that a defendant's entitled to information that will enable him to prepare an adequate defense. In a complex matter such as this, it would be unfair to require the defendant to conform mid-trial to a new novel or previously undisclosed legal theory. Therefore, the people will be limited to only those theories which they have already identified and are hereby precluded from introducing any new or different other crime theories at trial. Ooh, tricky. Ooh, all right. Judge is a little tricky here. All right. So what this means then is, so in a bill of particulars, if the prosecutor is forced to file a bill of particulars, it means only what they have set out in that bill of particulars can be used at trial. So rather than actually filing or saying to them that they have to file a bill of particulars, what the judge is saying is you are confined to those three theories, those three pre-approved theories, not the fourth one, because the fourth one wasn't pre-approved. You are only going to be able to use these three theories because we're coming up on trial and you didn't give any further information. So rather than ordering a bill of particulars or tossing the indictment because there was no bill of particulars, they're saying, well, you're set then on your theories that you gave to the defendant in response to their bill of particulars. So, all right, that was a good call. I can see that. All right, number 7, alleged grand jury secrecy violations. Oh my gosh. All right, here we go. Defendant claims that the rules regarding grand jury secrecy have been violated and that information leaked to the press has prejudiced defendant to such degree that it warrants dismissal of the indictment. Defendant points to several news articles he contends contain information which only the grand jury and those appearing before the grand jury would know. For example, there have been reports the grand jury was convened to investigate the defendant and that the same grand jury paused its proceedings for a time. Defendant refers to an article that presumably detailed the prosecutors had signaled to defendant's lawyers that he could face criminal charges. Defendant argues that because of the extent of the unauthorized disclosures is not known, a hearing at minimum is warranted, and he is entitled to all written communication between the DA personnel and members of the press regarding the instant matter. For the reasons set forth below, this branch of the defendant's motion is denied. All right, so he again is going for, we want all the information you know, your family knows, anything your dog wrote, we want all of that information. Grand jury proceedings are secret, subject to limited exceptions. A public prosecutor may not disclose the nature or substance of any grand jury testimony, evidence, or any other decision, citing case law. However, dismissal of an indictment for impairment of the integrity of a grand jury proceeding is an extraordinary remedy, which requires the moving party to meet a very high and exacting standard. All right, so they're saying, yeah, even if there were problems, you've not met that burden of getting it tossed because of that. There's a presumption of regularity that attaches to grand jury proceedings here, according to case law. Grand jurors, prosecutors, grand jury stenographers, grand jury interpreters, police or peace officer guarding a witness in a grand jury proceeding, clerks, wardens, and other public servants have official duties in or about a grand jury chamber or proceeding are bound by this law. That's a secrecy provision. However, others such as witnesses are exempt from the statute. And then we're citing commentary. This court has considered the arguments of the respective parties in tandem with careful examination of the grand jury minutes and finds the defendant's claims are without merit. All right, so the judge isn't even going to go further into that. They're just going to say, we do not think you have a claim whatsoever on this, so that one has been dismissed. All right, and 8, people's certificates of compliance. Defendant asked this court to strike people's certificate of compliance and to direct the people to comply with this discovery obligation. Specifically, defendant requested the court order the people to identify the exhibits they intend to introduce at trial in their case in chief. Defendant argues the people produced a list of 33 books in their automatic discovery form, but did not turn over the books, nor have they identified the specific sections of the books that will be referred to at trial. Oh my goodness. Defendant claims that this discovery violation will unfairly prejudice the defendant. The People's ADF contained Addendum A, which is a list of books and other material. The People note that the first page of the ADF contains language to the effect that counsel should contact the undersigned assistant should they wish to inspect, copy, photograph, or test any of the documents or items listed in their ADF. The People also argue that they informed the defendant in their first discovery production, dated May 23rd of 2023, that they intend to introduce all the grand jury exhibits at trial. The list of exhibits was included in their May 2023 disclosure. Ooh, you should read your paperwork, people. As this court discusses in Section 6, a defendant has a right to prepare defenses. It's only fair that the People should inform defendant which of the documents produced in discovery they intend to introduce at trial, particularly in a case such as this, which involves voluminous discovery. Here, the People have informed the defendant that they intend to use the grand jury exhibits as their exhibits at trial. They've also informed defendant that they will update the defenses as soon as practicable. As additional exhibits are identified, given the rapidly approaching trial date, the sheer amount of discovery produced thus far has required this section of the code. The People are hereby directed to identify the remaining exhibits, if any, that will be offered into evidence in their case in chief by May 15th. Okay, and that's 10 days before trial, everybody. So that seems fair. That's fine. I think that's a good call. Oh my gosh. So here, Trump is saying, hey, they're not complying with their discovery obligations. And the judge is saying, yes, they are. And if you have any more discovery, give it to the other side by March 15th. All right. Last page, everybody. We got the full order. Full order page. Finally, the court is aware of recent Court of Appeals decision in People v. Bay here, which was rendered after the parties had completed briefing on the instant matter. After reviewing the Bay case, this court does not believe its holding has any impact upon the issues here. Therefore, it's hereby ordered that the defendant's motion to dismiss the charges on the basis of pre-indictment delay, or in the alternative, is denied. So pre-indictment delay, denied. The defendant's motion to inspect the grand jury minutes is granted, but is denied as to defendant's request to dismiss the indictment for legal insufficiency. All right. The defendant's motion for production of the legal instructions to the grand jury and production of the complete set of grand jury minutes is denied. The complete set's denied. And it's ordered the defendant's motion for dismissal of the indictment on the grounds of selective prosecution is denied. So selective prosecution is denied. Defendant's motion to dismiss the indictment due to alleged violation of the statute of limitations is denied. Okay, so statute of limitations. Oh my goodness. Defendant's motion to dismiss counts in the indictment on the grounds that they are multiplicious is denied. And the defendant's motion for the court to order the People to provide a more robust bill of particulars, again, what we were kind of talking about before, we'll have to talk about that bill of particulars later on, is denied in part and granted in part. So the only thing that's granted is the 3 theories are all that's allowed to be used for that particular issue. For the object issue, everybody, all right, which is what they said they were going to use anyway. So, and it's ordered the defendant's motion to conduct a hearing regarding grand jury secrecy violations is denied. So that's also denied. And defendant's motion to strike the People's certificate is denied. So that's denied. And it's ordered the People are to identify to the defendant no later than March 15th the rest of the exhibits they intend to introduce at trial. All right. So there we go. That's and that's it. We have a denied. We have granted, minutes of testimony, denied, 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 half and half, denied again, denied, and then the caveat here. All right, so there we go. I'll go ahead and turn on comments, everyone, so we can chat a little bit about this New York order for those who are interested. Oh, my goodness gracious. Oh, what an interesting order. You really took care of everything here. I think all of the issues that were raised were taken care of. So that was a lot. It was a lot. It was a lot. Hello, everybody. Hello, welcome in. Good to see you. Yes, good afternoon. You know, there's just so much going on today. I was like, I knew I was going to need to do multiple. Yes. So, okay. So this is the New York criminal case, everybody, and there were multiple motions to dismiss, and the judge has denied them. So we are going forward. This trial that's set for March 25th is going to go forward. Can I see the cover sheet? So this cover sheet here, or do you want to see the order, the final order? Election integrity bill allowing conviction. Oh, that's interesting. Good for them. Okay, so this is the first sheet here. So we have our indictment number here and the decision in order, the final order. And then here is the final order. So each one of these is an order from the court. So he had multiple questions, multiple grounds to dismiss. They were all denied, pretty much. There were a couple of little caveats, but they were pretty much all denied. So the case is going to go forward. Yep, I'd free the jurors if they allowed. Yeah, I think, well, and it's just not necessary either. What are the charges? I get them mixed up. So the charges in this particular case, he's got, 30 charges, and they are all for falsifying business records. So I believe they're all Class E felonies here. So what happened, everybody, was that he didn't properly document the hush money that he paid to Stormy Daniels, meaning Michael Cohen came in, created this shell company, paid her, and then Trump paid Cohen, paid him extra money to cover his taxes, paid him like an incentive, like as a thank you, paid him back for the money he paid to Daniels, and none of that was properly coded. So none of that was properly written out. That's what this case is about. This case is, if you're going to pay somebody off, just pay them off. Don't try to hide the money. Don't use a middle guy to like take care of your business and try to be all fancy about it. You got to put that money where it needs to go, and you need to sign it off, okay? He tried to hide it. Yes. So that's really what we're talking about. We've got a tax question. We've got election question. So there was some kind of the reason why all of this happened was because he was trying to kind of be all, sneaky about what's going on in the election. And so these kinds of questions are coming back to haunt him. Why wasn't Trump charged? Well, I think there's just a lot of good questions regarding that. And Alan Weisselberg, he was charged too and has served. I mean, they've already served. He will serve jail time. I'm not sure. I think the jail time is pretty minimal on Class E felonies, even though he's been charged with multiples. So he's been charged with each invoice that was incorrect. He's been charged. So each one of those documents, he's been charged with falsifying that as a business record. But if it's a Class E, I don't know. And it looks like this is going to be the first criminal case to go. So it's unlikely someone without a prior criminal record would be serving time. But the quantity is so huge, it's possible. It's 4 years max per charge. Yeah, I mean, it's possible. because we're looking at, he's not president anymore. That's why he can be charged. But, we're looking at so many charges, and Cohen has already served time. Wesselberg has served time. So it's possible. No continuance. No, nothing's been continued. We are on course. We are on track for this March 25th trial, everybody. At this point, it's time to start preparing for trial. So, like I did when we were doing the speedy trial situation out of Georgia, it will be time to start going through the process of figuring out the jury instructions, going through what's a voir dire process in New York look like, what kind of motions, pretrial motions are going to be filed, those kinds of things. We are in the trial zone, everybody. We are in the trial zone. If they make it concurrent, it's not much. It's not much. It's not if it's not concurrent, but even 6 months prison for him would be a lot, wouldn't it? I mean, the trial zone, yeah. But yeah, because these are class E's, again, I mean, it's white collar crime. We're in a white collar crime world, everybody, and we don't really look at we don't really get a lot of unnecessarily time. Now, no, this will not be televised, but there are reporters usually in the room doing updates every 15 minutes. So in the E. Jean Carroll case, as well as in the civil fraud case in New York, the reporting was excellent to be able to have really quick responses about what was going on. So there is that. Any word from Judge Engoron? Not yet, and I am checking the docket about every hour. Finally, we got into the trial zone. Yes, we're in the trial zone, everybody. We're in the trial zone. We're heading to trial. We're going to trial. And this one's a criminal one. This one's a criminal one. If it were anyone other than him, they would. Well, I don't know. I'm considering, I think, because we're in a white collar crime situation, I'm not sure he would be spared prison time because of who he is, but rather because of these kinds of charges. Falsifying business records isn't, one of those, like forcible felony offenses. So that's my thoughts on that. Yes. How do you check the docket? So this docket's kind of hard to check, actually, this New York docket. I did post something a couple of days ago, or maybe yesterday, I can't even remember, everybody, on how to pull up the New York court system. So you can pull that up. You can go back through and look at that. Heard Judge Engoron's going to make his ruling today. Yes, Cynthia, I think so. Either today or tomorrow, I think we're going to have a decision from Judge Engoron. Absolutely, absolutely. How common is it for a defendant to refuse to be in court during trial? So if it's a criminal case, you have to be there unless it's like on the same day at the same time. Like right now, we've got New York and Georgia going at the same time, so it's impossible for him to be in both places. But if it's a criminal case, you have to show up because that's part of the constitutional right to confront, the witnesses against you. So you have to be there. You have no choice. What made what Cohen did worse than what Trump did enough to serve time? He had other bits and bobs included. So Cohen had other charges besides just these falsifying business records. He had other issues going on with like taxi medallions and various other things. So this wasn't just, a couple of things for him. He had other things involved. Said it will be tomorrow, they confirmed. Yeah, I mean, today or tomorrow, at any time. Yeah, trial zone. We're in the trial zone. Yep, absolutely. He has to be present in court every day of trial. Yes, he does, Elizabeth, yes. So the way I try to remind people is, I don't know who remembers, this was a long time ago, but one of the big, huge publicity trials was when Michael Jackson was on trial. And I don't know if anyone remembers hearing about this or not, but when Michael Jackson was on trial, it was a criminal case. And in that criminal case, there was a day when he said, Your Honor, I'm so sick, I can't come in. There's no way I can come in. And the judge was like, you need to come in or I'm going to put you in jail. And he showed up in like this, military jacket and pajama pants. So I just want everybody to remember the pajama pants situation. All right. You have to go to court. If Michael Jackson has to show up to court, everybody has to show up to court. Okay. So even if you're in pajama pants, if you have a criminal case, you've got to show up. So that's one way of kind of remembering. If the Prince of Pop has to show up, you need to get to court. You need to go to court. And it's, again, for criminal cases, unless, of course, it's scheduled at the same time. So, yes, well, yeah. Didn't he dance on the cart? He did. I remember it very well with the pajama pants. He found guilty. He was found. Yes, he can technically, Mystery. He can run. He can be president if he's found guilty. But it's possible for him to be immediately impeached, everybody. Because if you think of high crimes and misdemeanors, which is technically what you're actually supposed to impeach somebody over, not just for funsies on a Thursday, technically under the Constitution, high crimes and misdemeanors. And if you're convicted, if you're found guilty of felonies, that could be seen as high crimes and misdemeanors. So I don't know how he would get through an impeachment other than, his, rat foot soldiers in Congress. Yeah, I don't know. Yeah, I don't know. And I hate to use the term Republicans because that there's a mixed bag when it comes to that particular term. We've got some rats and then we have some other Republicans. Oh, yeah. Moving to the country, going to eat a lot of impeachments. Oh my goodness. Oh my gosh, that's so funny. Oh, yes. Well, yeah. Could this case have an impact on Supreme? No, I don't think so. No, it's case by case, and the Supreme Court definitely has blinders on. They really only focus on what's in front of them. I mean, they hear the I'm going to say old words today, everybody. They hear the scuttlebutt, all right? But they're really focused on whatever's in front of them. So, oh my goodness. I thought the president must be dead. No, oh no. No, of course not. No, debts all over the place. George Washington had a lot of debts. I mean, don't get me wrong. His wife paid them, but he had a lot. Oh my goodness. Yes, I mean, technically under the Constitution, can you run? Yes. Can you win? Yes. But can you be impeached for high crimes and misdemeanors repeatedly, like over and over and over again, so that you can't get any work done, so that your vice president's like, look, you can't get any work done, I need to take over? Probably. Yeah, he was, where's my big calendar? Oh my gosh, I'll have to get it out later, everybody. I have it in my other room. Oh my gosh. I have it in my other room, but I will be back again multiple times over the next few days. There's just so much going on, everybody. So much going on. I will be back again tonight at 7 for sure. 7 o'clock Central to go through an update on the calendar. We also have to go through some filings that have been done. We'll kind of talk about what's going on in Georgia a little bit. If the Supreme Court shoots down the hearing on immunity trial, do you think Trump starts to plead? So the only reason any of these trials are happening is because he's refusing to take a plea. There's no way in the world that these attorneys weren't trying every way possible to try to get a plea deal, because that's what you do. When your cases are this strong, okay, when your cases are like, man, I don't know, then you're like, man, let's go to trial and see what happens. But when your cases are this strong on the facts, which again, I say that based only off of what we've seen. We haven't even seen was actually available. We've only seen what's been made public. Like you plead it out, man, but they're not going to plead it. I mean, he's not going to plead it. Fani Willis is on fire. I don't doubt it. I would be on fire if I was her too. I'd be so mad. This situation is just absolutely redonkulous. It's just, yeah. I don't think Sent you a DM. Okay, excellent, Sarah. I'll take a look. I'll take a look. He's hoping he can delay. Yeah, and I mean, you can delay, but only for so long. Even in the legal system, eventually, it's going to hit the fan eventually. And it's slow, and the American public is getting exhausted. But, you need to hit your energy drink, everybody. You need to hit your energy drinks, all right? Because I'm not doing this alone. We're going to all do it. Well, yeah, I mean, we don't know anything about that. We don't know anything about any of that. Nor does it matter. I don't want to know. Diet Coke, whatever. Yeah, exactly. I don't need to know about the personal lives of attorneys. Like I've been in that world, and people, it's ugly. That's a messy world I don't care to be a part of. I don't want to be a part of that. I don't want the details. You just don't. Sometimes you're like, I wish I wouldn't have known that. You can't go back in time. Oh, yes, yes. What case is this? So I just went through the New York criminal case that we had the judge rule on today. All of the motions to dismiss have been denied. A couple of bits need to be added to kind of clean things up a little bit, but everything has been denied to a point where we are set to go into trial. I feel like I was invading. Yeah, I mean, I'm watching it with the sound off just to watch the body language, but I can't actually listen to the words. I just can't, everybody. I'm not ready. I'm not ready. I'm not ready to listen to the words. I mean, I look at their faces, but I'm like, this is just banana boats. Banana boats. And I understand people like the, interesting, like, controversial, woohoo, whoop-de-doo-dah stuff. I get it. But, I've been burned out on it. So I'm burned out. I'm burned out on the whoop-de-doos. If he wins, no, I don't think so. I mean, if he was to win, we've got, cases proceeding. I'm not sure you can just kind of pause cases. I mean, if it's going, it's going. Because it's, if a president, there's some rules going around like, oh, president can't be charged criminally. Well, yeah, but he's already been charged. He's not president right now. So is there a rule that says he can't, finish his criminal trial? I don't think so. But at this point, I don't know. No, it wouldn't. Well, I mean, I don't know, CC. It's hard because I think this really shows how, I'm just going to put it out there. I think if Fani was a man, this wouldn't be an issue. This would not be an issue at all. But Fani is a woman. Miss Willis is a woman. And so now we're going to make a big deal about it because that's how it works in the legal field. There may be a lot of women in the legal field, and we've got judges all over the place, and half of our U.S. Supreme Court is women. But that just makes it look good on paper. But in the reality, when you walk into that courtroom as a woman, yeah, there's a difference. Yeah, and it could very well be race as well. I don't know, given the circumstances of where they're at. I just don't know. I think that's one point that she raised, but again, I think the fact that she's a woman is taking precedent over it. Mm-hmm. Another woman's being dragged through the mud for his... Yeah, I know. I know. And it'll keep happening, everybody. It'll keep happening. Anything that they can go after, it doesn't matter, how low. I mean, how low can you go? He can go as low as he wants to go because he doesn't see his behavior as going low, Mr. Trump. He just sees it as, this is just what you do. So he's on a little different scale. Gets away with, well, he sneaks around. He's sneaky. But the thing is, everybody gets away with a lot of stuff. It's just who gets called out on it. Just not everybody gets called out. And it's not just Mr. Trump, everyone. It's a lot of people. It's not that people aren't making mistakes and doing bad things. It's that if you have a certain level of, prestige or whatever, you just don't get called out on it. And I think the best example, of course, would be Elon Musk when he said, hey, just for funsies, yeah, I'll buy Twitter. And then was like, just kidding. And the courts are like, hey, dude, no takebacks. Like, who calls him out? Well, the courts do. And so finally, the courts are the ones calling out Mr. Trump. And it just takes a while. It takes a while to get back to do that. Yeah, I mean, yeah, this is happening all over and has been, will continue to. It's much better than it used to be, everybody. And I think right now we're really at a pivotal turning point where someone at this level is truly being called out for, their shenanigans. So what eventually happens, I do not know. But it's this whole process of like, hey, even you have to abide by the law, dude. I think is really important. So painful for all of us to go through. Painful, but I think it's showing a turn. We're having a turn in our society now where we're like, I think we need to. What can stop him from being president? Well, I mean, you have to vote for someone who's not him. To vote. Where's Trump right? Oh, I have no idea. Rumor had it he was in New York, but who knows? Yeah, you have to vote. That's the key. So, yep, legally. Oh, he's heading to trial. We're in the trial zone, everybody. We are in the trial zone. And my prediction, I forecast that each one of these cases will go at the way that they originally were charged, even though I've got some questions about Florida. Florida's the only question I've got because none of the judges here are trying to put things on hold like the judge in Florida seems to be doing, but because she doesn't really seem to know exactly what she's doing, but whatever. But I think we're in pretty good shape here. I think New York's going to go, and then I think we are going to have Florida, we're going to have DC. I think we're going to have one of those two cases. They were both filed pretty close together. We're going to have Florida, we're going to have DC. I think we're going to have one of those two cases. They were both filed pretty close together. All right, sorry, everybody. Yikes. Woo. Sorry about that. Oh my goodness. Boy, we had some madness there. Oh my gosh. Sorry about that. Well, with that, everyone, I do need to go at this point. I do need to go. I will be back on again tonight. Yeah, I had a call come in. Sorry about that. But I will be back on 7 o'clock Central Time tonight, everyone. We will be going through some good stuff, and I will be on multiple times over the next few days to give everybody updates. So I will see you all later. Thanks for coming and hanging out. It's always great to see everybody. So we are now officially in the trial zone in New York, everyone. Yep. So take care, and I will see you later tonight.